Selling your patent. This presentation identifies what's involved in selling a patent and what patent holders can expect when they embark on the process of approaching potential patent buyers. Before going any further, let's address any misunderstandings about what a patent is. A patent is a right to exclude others from practicing your unique patented invention. The patent claims form a fence around your intellectual property, and the publishing of the patent creates a keep out sign preventing others from entering. If someone enters, they're an infringer, and you have the right to sue for damages in court. Some patent holders are surprised that a patent does not automatically provide them with the right to practice the invention themselves. The reason is that patents overlap, and components of one patented invention may infringe those of another patent. If you owned the patent to a bicycle, for example, you may be restricted from making, using, or selling such bicycles because the wheels are patented by someone else, and that patent holder would have the right to ask the court to exclude you from infringing their wheel patent. Remember, a patent is merely a right to ask the court to exclude others from practicing your invention. When you're selling a patent, you're selling the right to exclude others practicing your invention without a license. You're selling the right to bring enforcement action against infringers in federal court. As patents can spawn children, the buyer also receives the right to file continuation patent applications based on the original invention and benefiting from the original filing date. Selling the patent usually means giving up future licensing royalties, but ongoing royalty shares can sometimes be negotiated into the transaction. Many patent sales include a license back, allowing you to continue to practice the invention without fearing being sued by the new patent holders. If you negotiate a license back from the buyer, selling your patent means simply assigning the right to bring lawsuits against infringers. It's important to understand that selling your patent does not necessarily mean selling your products, your business, your copyrights, or your ideas. Unless you employ armies of lawyers, selling your patent could mean selling a right to litigation that you're never going to use yourself. Selecting which patents to sell depends on your business, your portfolio, and your strategy. If you're unable or unwilling to enforce a patent against infringers, you're sitting on patent rights that you're never going to use. Small companies without teams of patent litigators often generate incremental revenue by selling patents, even patents supporting their existing product range. Most patent buyers are prepared to grant the seller a license back to continue to make and sell products incorporating the patented invention after the patent has been sold. So, sale of the patent does not harm the company's ability to pursue product sales. In fact, for many small companies that don't employ armies of lawyers, the transfer of the patents to a large buyer actually helps them compete in the marketplace. Where competitors ignore the patent rights of small companies, they're forced to stop sales of infringing products by the credible threat of litigation from a large patent holder. There are good reasons for large corporations to sell patents as well. If your business is shifted or is in the process of shifting direction, your patent portfolio may no longer mirror your range of products. Changes in corporate strategy often leave discontinued products and redundant patents that are no longer core to the company's business. Divesting of discontinued intellectual property can generate significant revenue for a corporation. The highest value is often achieved when selling portfolios of patents in related fields together with their families of children and international counterparts. The value of a patent application that's not yet been approved by the Patent Office is highly speculative, as it depends on which claims, if any, are allowed and which claims are to be rejected. If some claims are allowed, but the scope narrowed, then the value of the patent can be much reduced. If none of the claims are ultimately allowed, the patent is not issued and is worth nothing. So patent applications and provisional patents are generally difficult to sell unless they're sold in families together with related issued patents. Sometimes a buyer will acquire the application, step into the shoes of the inventor, and prosecute the process with the patent office, hoping to get the claims allowed. Alternatively, a buyer may enter an arrangement with the inventor that the buyer agrees to buy from the seller and the seller agrees to sell to the buyer when the patent is approved. This can involve the buyer acquiring an option on the application that's triggered when the patent is approved. Like any property right, a pending patent application can be sold or promised. However, the best approach is often to wait until the claims are allowed and the patent is issued. Selling without really selling. The bundle of property rights that make up a patent can be unbundled and sold in separate transactions. In cases where the research and development was financed by government funding and other situations, the patent holder may be restricted from selling title to the patent, but has broad rights to license. It is possible to sell almost all the patent rights without transferring title. This type of transaction involves selling an exclusive license with rights to join the patent holder in any enforcement action. The seller in these transactions often requests indemnification, so the seller and the title holder can be joined in the legal action, but the buyer is fully responsible for legal fees and the associated costs. So in short, there are ways of selling patents without transferring title. The process of selling a patent usually takes 6 to 9 months. The initial stage involves preparing the marketing materials and posting the listing on the exchange. Then the listing is circulated to buyers and their agents. Much of this is done anonymously, as both buyers and sellers often wish to operate in stealth mode. When a buyer has real interest, confidentiality agreements are entered and more detailed information is exchanged. A tentative offer from the buyer often results in a counter-offer from the seller and some negotiation over price. When the price has been agreed and a term sheet exchanged, the final paperwork is prepared and due diligence conducted on the file wrappers and the patent filing records. The closing takes place after both parties have agreed to the patent purchase agreement and due diligence has been completed. Funds are transferred in exchange for ownership rights to the patent. Bearing in mind the paperwork involved and the due diligence to check the validity and clean title to the patents, the minimum time required to complete the patent sale is probably in the region of 6 to 9 weeks. But patent sellers should be prepared for the typical transaction taking 6 to 9 months. Patent sellers are often disappointed to discover that their calls to potential purchasers go unanswered. There are very good reasons for this. Knowingly infringing a patent carries 3 times the damages as unwittingly infringing. So companies simply don't want to know about patents that may be in their field. The same goes for patent attorneys, who don't want to be put on notice of a patent, as this triggers a duty for them to disclose this knowledge to the patent office when filing new patent applications. If companies and their patent attorneys do know about your patent, they certainly don't want to confirm their awareness by communicating with you, as they see this as simply creating evidence that you can be used against them in an infringement lawsuit. So if you're looking to sell your patent, don't be surprised if you receive no response from potential buyers you approach directly. Of course, lawyers will be involved in negotiating and structuring the transaction itself, but they're also usually responsible for analyzing the patents, carrying out due diligence, and managing negotiations. As patents are essentially legal instruments, carrying a right to sue infringers, lawyers are often the employees in corporations charged with the responsibility of buying patents and interacting with patent sellers. Even if you find yourself dealing with an individual from business development or another business unit, don't be surprised to find lawyers attending your meetings or forcing confidentiality agreements to be signed before any serious discussions can take place. Your friendly approach to a buyer can easily trigger a legal response in the form of a letter denying infringement, even threatening a lawsuit to prove it. Don't be surprised if your friendly sales approach to a buyer results in a rather unfriendly legal response. By putting them on notice of your patent, even in the friendliest of ways, you could be triggering the first stage in an infringement lawsuit. Be prepared for a legal-oriented response. It's difficult to avoid lawyers when selling patents. There's often a large gulf between the price a patent holder would hope to receive for the patent and the price a buyer is prepared to pay. When offers are finally received, they can be somewhat sobering to the seller. We do have other slides and presentations that focus on patent valuation, but here's a quick summary of what patents sell for in the real world. A patent that's invalid is worth nothing. You may find this obvious, but over 50% of patents that are issued by the Patent Office and subsequently litigated are then found to be invalid in court, often because some prior art was overlooked when the patent was originally filed. Most patents actually sell for the price of a new car. Some reach the prices of luxury models, while others only reach the price of an economy runaround. A small percentage of patents, usually those with clear evidence of infringement, can sell for the price of a house. If the infringement status is compelling and the patent is battle-tested, it's been successfully litigated in court, the value can reach $1 million or more, but million-dollar patents are very rare. Patent sellers have to provide a good deal of information to their brokers and patent buyers. Of course, the buyer needs to know the patent numbers, and these are usually provided early in the process once the buyer's been qualified. Pricing guidelines from the seller are often necessary for the buyer to consider the listing seriously. Buyers don't want to waste their time reviewing patents if the seller's price expectations are unreasonable. The broker will want to know about any prior sales efforts so that they don't chase buyers that have previously been approached. The status of the patent family, including continuation and international counterparts, will be requested by serious buyers. If you want to sell the patent but retain a license back for your own continued use of the invention, it's advisable to inform the buyers of this early in the process. Some buyers will be interested in detailed information on infringers. Almost all buyers are going to want to know about any licenses, liens, or encumbrances affecting the patents. Gathering all this information when the decision is made to market your patents will help speed up the sales process. Due diligence in patent sale transactions usually focuses on two areas: validity of the patent and clean title. All buyers clearly want to make sure the seller owns the patent rights that are being acquired in the transaction. So the seller is requested to provide the buyer's lawyers with documentation proving that assignments from inventors and prior owners or assignees have been properly executed. Licenses, liens, and other encumbrances are reviewed in this process. Any disputes over who owns the patents being sold can take some time to resolve and seriously delay the closing. Some buyers look to investigate the validity of the patents by searching for prior art and reviewing the correspondence with the Patent Office and all the file wrappers. This review often uncovers continuations, foreign filings, and other family members that affect the value of the patent. There are several contracts and agreements involved in selling a patent. Firstly, the seller often engages with a broker or intermediary in a representation or marketing agreement. Confidentiality agreements are signed with buyers, intermediaries, and others involved in the transaction. The sale and transfer of patent rights is handled through a patent purchase agreement. This is usually a lengthy document drawn up by the buyer. Once the transaction has been closed, it's recorded at the Patent Office as an assignment. So, selling patents through an intermediary can be conducted in stealth mode, where the identity of the buyer and the seller are kept confidential until NDAs are in place. Brokers are often prepared to work solely on a contingency basis, where the compensation is a percentage of the transaction. Many patent sales involve a license back that allows the seller to continue to market products using the patented invention. US patents are the most valuable, and they are often sold together with their families of international counterparts and continuations. Portfolios of related patents with overlapping claims covering a specific technology are the most marketable and often fetch the highest prices. So large corporations, institutions, research labs, small startup companies, and individual inventors can all generate profitable revenue from selling patents.